Hi, welcome back again. In this short subunit, we're going to talk about breach and cure. All right, in this subunit, we're going to talk about two little leftover issues with respect to breach. Right? The first issue is what must occur for the other party to be in breach, right? So you might think, well, just non-performance. That's all that needs to occur. Well, something else needs to occur, and we'll talk about that. Then the second issue we're going to talk about is if a party is in material breach, do they have an opportunity, a legal right to cure that breach? Do they have a legal right to fix the problem? All right, let's talk first about what must occur for the other party to be in breach. Okay, so here's an example. A contract for the sale of a house. At the closing, seller does not deliver marketable title. At the closing, buyer does not produce payment. So the question is, who's in breach? Is it the seller in breach? Is it the buyer in breach? Or is it both of them in breach? You might say, well, they're both in breach. Seller didn't perform her promise to deliver marketable title to the buyer, and buyer didn't perform his promise to pay for the house. Well, actually, the answer is neither party is in breach. Remember, these are constructive conditions concurrent. They have to happen at the same time. So let's phrase it this way. Buyer's obligation to pay is constructively conditioned on seller's producing marketable title. Is constructively conditioned on seller's performance. Now, seller's promise to deliver marketable title is constructively conditioned on buyer's performance, buyer's payment. So in this case, neither party's obligations have arisen under the contract. Why? Because the constructive condition to either party's or both of their obligations has failed. The other party has not performed. So in this interesting case, neither party is in breach. Now, what would I need to do? If I were the buyer in this situation, what would I need to do to put the seller in breach? I would have to tender payment. What is tender? Well, there's long definitions of tender, but this is the definition I like. An offer to perform with the present ability to perform. What is the most common paradigm example of tendering payment? I reach in my pocket, I take out the money, and I say, here. That is tender of payment. Have I actually paid you? No, I haven't paid you because you haven't taken it yet, but I have tendered payment. So I would have to tender payment. Now, in this case, buyer could not tender payment because it says buyer doesn't produce the payment. So buyer didn't tender payment. But if buyer had the check and was ready to pay, buyer could tender the check and say, here, I'm ready to pay. And then that would put seller in breach. Likewise, seller would just have to say, here's marketable title. And if then buyer cannot produce the payment, buyer is in breach. So when you have these constructive conditions concurrent, to put the other party in breach, when the other party hasn't performed, to put the other party in breach, you have to tender your payment. Now, there's a little exception to that, and the exception should make sense once we go through that, in a situation of anticipatory repudiation. So let's just change the fact pattern a little bit. We still have a contract for the sale and purchase of a house. Now, before closing day, before law day, seller says, I will not perform. Okay, so at this point, seller has anticipatorily repudiated the contract. But what does buyer do in response? Buyer goes to the bank and withdraws her application for a mortgage. Right? If you're not going to perform, I don't need the mortgage, so I withdraw my application for the mortgage. So remember, these are constructive conditions concurrent. For buyer to put the seller in breach, buyer has to tender performance. Could buyer tender performance in this case? No, buyer couldn't tender performance, right? Tender means offering to perform with the present ability to perform. Does buyer have the present ability to perform? No, buyer never got the money. Buyer never got the mortgage. So buyer would not be able to pay for the house. So you can understand why this doesn't make sense if we apply the rule this way. And so this is the rule. The rule for the anticipatory repudiation situation is there's no need for the aggrieved party, the non-breaching party, to actually tender performance. What the non-breaching party has to do is show that they would have been ready, willing, and able to perform, but for the anticipatory repudiation. So buyer would just say, look, the only reason I don't have the money is because I withdrew my application from the bank as soon as the seller anticipatorily repudiated the contract. If it had not been for that, I would have been approved and I would have had the money. Okay, now let's talk about cure. And this is the idea of cure. We have a party in material breach of a contract. Does she have a legal right to cure her material breach? I've goofed up and now I want to make things right. Can you at this point now cancel the contract and walk away and say, nope, you're in you're in material breach and I'm walking away from the contract? Or do you have to give me a chance to make things right? Do you have to give me a chance to cure? Well, the answer might be a little unsatisfying, but you're used to that by now. Maybe, depending on the circumstances and the jurisdiction. I would say it's just very fact specific, but this is generally the pattern you should be looking for, right? A party's in material breach, the party fails to cure the breach, then that party is in what we call total breach. As soon as that other party is in total breach, the non-breaching party can walk away from the contract, can cancel the contract and sue for breach. Okay, so once again, the pattern is material breach. Now, when we have a party in material breach, the other party, the non-breaching party at this point, might not be able to walk away from the contract, but the other party can suspend her performance. So if you're in material breach of our contract, at this point, in most jurisdictions, what I'd have to do is I'd have to say, you're in material breach and I'm suspending my part of the performance under the contract, right? Then, if you don't cure within a reasonable period of time, you are in total breach. And when you're in total breach, now not only can I suspend my performance, but I can cancel this contract, walk away, and sue you. So look for that pattern. It's not that hard to figure out and not that hard to spot.